one case on the calendar this afternoon, Paul Allen Dundor, M.D. Versus Teresa Hamill. Counsel for the petitioner may proceed.
Thank you, Your Honor.
It says appellant on there, but I presume you're the petitioner.
We are the petitioner.
Okay.
First of all, I'd like to say that I'd like to reserve 3 minutes, if I could. Thank you on behalf of Dr. Dundor and Jack's Pathology for agreeing to oral argument and considering this appeal. In this case, the required procedural aspects of pre-suit were not followed by the plaintiff, violating the legislative intent of Chapter 766. Respondents' lack of cooperation denied Dr. Dundor his right to investigate the claim, determine its validity or invalidity, whether it was founded on irrefutable fact or was frivolous, before a lawsuit was filed, and the inevitable financial expense to the parties and to the state of Florida, time allocated and mental strain incurred on all the parties. Paul Dundor and Jacksonville Pathology Consultants were denied the essential process guaranteed by law. The law gives all claimants 2 years and 90 days to investigate their claim. That's 720 days, no leap year. During that 720 days, there is no restriction on when they review the evidence, where they review the evidence, or what expert they hire. If the most knowledgeable expert is in California, the claimant can take the slides, in this case a pathology case, can take the slides with him and take them to California and have that expert review the case. They can go and do it at their time and to whatever expert of their choosing. There is no way that they're interfered with or conditioned in any way, shape, or form. Instead of having 720 days, Dr. Dundor and Jacksonville Pathology only had 90. And that's based on the legislative conduct. And the 720 days, just so it's clear, is the 2-year statute of limitations from when they knew or should have known. Plus, you can, under the statute, you can file a 90-day extension. So that's the 720 days. Once they file the notice of intent, Dr. Dundor only has 90 days, and not the 720, to fully investigate under the legislative construct. During this 90 days, the law requires the plaintiff to cooperate. That's 766-106. And 766-205, the plaintiff shall provide reasonable access to information within its possession or control. Sub 2 says the failure to do so shall be grounds for dismissal. What happened in this case was, during that 90 days, the plaintiff never provided access. What happened...
When you say never provided access?
Access to the slides.
Didn't they have access where they were located?
Pardon me?
Didn't they provide access where the slides were located? They were in a hospital and...
They never... No, actually they didn't. There was one letter which is attached as the appendix, and that is plaintiff's letter, I have it right here, of November 17th, 2010. And this was after we had asked on several occasions. I could go through them all. They're before you. I don't need to, but this was probably the 4th letter, or in response to our 3rd or 4th letter saying, please send us an authorization. And in that letter, plaintiff says, dear Mr. Childs, and I'll skip some of it, until additional facts are known, Mrs. Hamill does not consent to releasing custody of any of Mr. Hamill's pathology specimens. I believe all parties need to have an understanding of what specimens were seen by Dr. Dundor and what specimens were seen by M.D. Anderson pathologists. Now, he already had all those medical records. That's actually in the medical records.
There was never any offer to have the defense expert go to where the slides were located?
Well, I'm not done. That's the next paragraph, Your Honor. He says, I expect your expert will want to see pathology. He suggested a deposition. That was really the next thing I was trying to put in context of his letter. A deposition. Of course, we weren't in suit, so we couldn't have a deposition. But he was in suit with the co-defendant. So he could take the deposition of the custodian of the slides at Baptist Medical Center. But he suggests that and suggests that Mr. Reagan, who is one of the counsel for Dr. Cohn, may be interested in that. And then he says, I expect your expert will want to see the pathology before this discovery deposition could occur. Well, I guess he's trying to tell me when he needs to see it, although we'd like to see it. We wanted to see it earlier. Why don't you propose dates your expert is available to observe the slides at the custodian location, and we will cause to be delivered to the custodian the appropriate releases? So he has put that condition. He said, I'm going to, first of all, you have to have an expert. I'm limiting you and your experts because it has to be somebody who is going to come to Baptist Medical Center or is going to be in Jacksonville, Florida. He has no such limitation. The statute was never intended to have any such limitation.
I was just going back to your word, access.
No
access.
Well, and the reason I said that, Your Honor, that's thought out, is that let me this sequence of letters is actually I think important, and I'll go. The NOI, the notice of intent, was on October 6th. On October 28th, we sent him a letter, said here's a HIPAA compliant authorization. Would you sign it and send it back? On November 1st, we sent him another letter, and in that he sent me a letter, and he said, well, I'm concerned about chain of custody. So I sent him a letter back, and I said, here's an order, and that's also in here, that we've used in other pathology cases that have been entered by judges that takes care of chain of custody, and it's clear who has the slides, and if anything happens to them, where they are, and so they're protected. Nothing came of that, and since he was in suit, he could have that entered. Then on 11/8, we had set up a teleconference so that we could work out the details. He canceled it, so we never had it. Then on 11/11, I wrote him again and repeated, said, please send us an authorization. We've got to be able to investigate this case. On 11/17, we send him a letter again, say send us the affidavit or send us the authorization. And by the way, we noticed that it appears that your expert never even saw the slides, so we don't think that's a good faith affidavit.
Well, what did the trial judge say about all this?
Well, he didn't say anything at first, Your Honor. The order that was appealed is just, he denied our motion. We moved to stay, obviously, because this is an active lawsuit. And at that hearing, I don't want to, I let him speak for himself, but he wrote a long order trying to explain his reasoning. And he said, basically what he said was he thought, well, there were, both sides had good arguments, but I'm not going to prevent the plaintiff from going forward, and I'm going to consider this just a good faith disagreement.
But he say in the order that access wasn't totally denied, that they had agreed to allow you or your expert to examine the slides at the hospital.
I think, Your Honor, I think that is not access as stated.
Well, let's talk about that. Is there anything in 766.205 that prescribes a particular method of access?
It says that, and I know you have it in front of you too, it says that they shall provide reasonable access to information within their possession and control. Now, there's no question about it. It was in their control.
Well, if it doesn't say that it must be done a particular way, for example, the way you'd like for it to be done, then how can we say that the trial judge departed from the essential requirements? How could we even say that the trial judge made any mistake of law, much less departed from the essential requirements of the law?
Judge, for this reason, the legislature states very clearly it doesn't say any kind of or limited access or whatever the plaintiff wants or cares to do. It says it has to be reasonable access. Now, for example, if you want...
is reasonable access defined anywhere?
Not that I see, Your Honor.
So the trial judge exercised his discretion in making an assessment about what reasonable was or was not. Is that fair to say?
Well, I think, Your Honor, that, and I understand what you're asking. I understand what the trial judge tried to explain in his other order. I think access is not whatever my whim is as the plaintiff. I can make it so you can have access, which eliminates my right or my client's right to defend the case with the experts he wants or how he wants to do it. That's not access.
Reasonable access.
Or that's not even access. And we've been forced to go forward. We have two experts. One's in New York City. One is at Johns Hopkins in Baltimore, Maryland. They're not coming down to at some arbitrary time. These are quite frankly extremely busy and famous physicians. But that eliminates all that. That forces us to get a pathologist in Jacksonville, Florida, who is willing to do it. And I don't want to approach. I'm just used to doing that. So it makes it so that we can't defend the case. That was never the intention of the legislature.
Well, you're not defending the case yet. This is just
well, even investigate the case. But we are determining. We have, as I said, they have 720 days to do whatever they want. We only have 90 days. And if Your Honors were to construe the statute just as suggested, we really are limited in how we defend it or how we investigate it. We're limited in who we choose because now we're going to have such limited access, we can't get who we choose.
But you're sort of into the way in which this pretrial pre-suit screening process is executed. And if I understand the Supreme Court case correctly, they're more concerned about, and in the punitive damages case, which is a very close parallel to it, both of those punitive damages cases are both very clear parallels to this. The court is concerned about protecting the process that your client is entitled to have, not the finer points of all of this, like how this is done or such as that. It's more a question of, was your client deprived of the process that is guaranteed by Chapter 776? And it seems to me we're sort of deep in the weeds about details of how the process was carried out.
Judge, I disagree with you.
Okay.
For this reason. To do the process is more than just saying, well, I sent you an affidavit, or I gave you access that you couldn't even do, or access that limits your ability to defend the case or to have it reviewed as you need to have it reviewed. That's a procedural violation by doing this. They have prevented us from being able to take advantage of the guarantees of the statute. And I don't think it can be looked at, as you suggested, Judge. I think that's not what the legislature intended. And quite frankly, it totally emasculates the statute. Why even have it if that's allowed? I think it goes against the intent of the legislature.
If we have a judge who says, I know what that thing says, but I don't really care about giving a notice of pre-suit and giving you a chance to investigate that. I'm going to go on and let you file your complaint right now. Well, now you have a situation in which a statutory right, which your client is entitled to exercise, has been denied. But it's not I don't interpret the Supreme Court cases as an invitation to litigate every detail of every pre-suit screening process, how it's carried out.
Judge, without going through all of it, because I'm running out of time.
Well, I'll tell you what, we'll give you a little bit more time because I used a little of it for you.
Yeah, let me just kind of go to that for a minute. The point here is, and what you were saying, your example, the point here is, if you actually look at the facts, we never, and even till today, have gotten an authorization. Nor has an authorization ever been sent to Baptist Medical Center.
That's your choice, isn't it? Not to take advantage of the opportunity to go to the location where the slides are located?
We wrote him back several times and kept saying, send us an authorization. Now, we wrote him and said, we disagree with your interpretation of the statute.
But for whatever
but
reason,
send
you
us an
elected not to send your expert to the hospital.
He has a affirmative duty under the statute to send us an authorization.
Who's he?
I'm talking about plaintiffs, the claimant. They have an affirmative duty to do it, to cooperate, and that's what the law says. And they didn't do it. He could have sent me an authorization that said, this is restricted to Baptist Medical Center. Never did. We never got anything. That's an absolute denial. I got 11 seconds.
Here's what we'll do. We'll add 2 minutes for rebuttal since we were kind enough to use some of your time for you. And we'll add 2 minutes to counsel for the respondent's time, which you may use. You're not required. There's no law that says you have to use it, but you may use it if you wish. Okay?
I appreciate the questions.
Thank you.
Thank you.
Afternoon, Your Honor. Jesse Harrell on behalf of the Hamels. I think Your Honors have already addressed many of the points that I wanted to make.
Is there a factual dispute about whether or not there was availability was made under certain criteria? I mean, opposing counsel seems to suggest that there was no opportunity to inspect or evaluate or examine, whatever you characterize that.
Yes, Your Honor, there was a factual dispute. In fact, the letter that he was reading from, which is at page 56 of the appendix, made clear that if they proposed dates, that their expert would come to the location, that they will deliver the appropriate release. The petitioner made clear that that was not acceptable to them, and so the release was never delivered. It seems that you shouldn't have to deliver a release that will be a nullity. The point of not the point of the statute, but the statutory language itself only requires reasonable access. And so the trial court looked at all the evidence. It had this letter. It heard the arguments about how actually the petitioner originally sequestered the slides so that they would be protected and that nobody would be able to take them out of the hospital, that Baptist would be the custodian. And the respondent, the Hamels, were actually preserving the status quo by saying, leave them with Baptist, have your expert come. And really it's no different than if they had wanted to do a pre-suit IME. They can hire any doctor they want in New York, but they can't force the plaintiff to get on a plane and go up there. This is pre-suit investigation. This is not denying them the opportunity to pick who they want to defend their case. It's simply a reasonable investigation to say there's a good faith basis.
Well, what prejudice would there be to your client to allow them to transport under a chain of custody and security necessary to preserve the integrity of the exhibit, to allow that to be transported somewhere else for an evaluation? What prejudice is there?
Well, the prejudice was, one, there was not a chain of custody agreement in place, and my client didn't agree to the terms of the chain of custody agreement that the doctor had sent over. In fact, the one that has since been entered has several differences from the proposed order sent over. But additionally, you got to remember that there is a gastroenterologist in this case as well. And the reason the pathologist was brought in is because during his deposition, the gastroenterologist said the pathologist misread the slides. I'm raising my affirmative Fabre defense. So the plaintiff in the case now has a duty to protect those slides not only for their own potential claim against the pathologist, who has a right to those slides, but also the gastroenterologist, who, if those slides are lost because the plaintiff says, sure, go examine them wherever you want, the gastroenterologist then gets summary judgment on a spoliation claim. So there was a real prejudice. There's a balance of interest, and I think it's really telling that the defendant themselves are the one who originally sequestered the slides, that they would be secure and could not move around the country. There was talk about how we had 700 and something odd days to have whoever we wanted to investigate it. That was not the case, and the record is clear that once these slides were sequestered, the only way to get those slides was with a court order. Our client was only getting recuts at this point in time in the pre-suit investigation, which is about the bottom 20% of the original specimen. So it's not like they're getting recuts of every original level of what the defendant doctor looked at. And the originals, which is another one of their complaints that we didn't see, that our expert didn't see, we didn't have access to at the time.
Is reasonable access defined anywhere?
It is not, Your Honor. And I think that goes back to the fact that trial court found that access was not entirely denied, but this was a good faith dispute. And even under the statutory language, dismissal is not mandated. There's discretion there. And so how you can say that the trial court departed from the essential requirements of the law when he had the opportunity to exercise his discretion and made a factual finding that there was a dispute over possession of this slide, not access, it's really not appropriate for certiorari review.
Counsel says that the failure to provide a reasonable access, or what he regards as reasonable access in this case, the way it worked out, was tantamount to a denial of the process that is guaranteed by the pre-suit screening statute. If he's correct about that point, then at least it would be correct to say that certiorari lies. Would you agree with that?
If he is correct about that.
Otherwise, certiorari is not even a proper remedy, but it seems to me.
Yes, Your Honor.
But if he's correct, certiorari would be a proper remedy.
It would be for Your Honors to look and make the determination of whether that process was actually denied, but we still feel the petition should be denied. Ultimately, we believe the petition should be dismissed.
Well, can you make the case then that what is your best case for the argument that access that was provided was in fact reasonable?
In addition to the fact that the trial court made that factual finding, and we're not here to
Well, we're not here to make that determination initially, I understand.
You have the fact that the plaintiff offered to sign the release that would be necessary as long as the custodian remained Baptist Hospital during this pre-suit investigation. Now, what happened once you got into the litigation is another matter altogether, and that's been dealt with separately.
Can I ask you this?
Yes.
Before the trial judge, was there any record evidence that the ability to view the slides at their location would be sufficient for someone who is investigating and evaluating the claim? One way or the other. In other words, their position is we couldn't do that. Was there any evidence presented that it would be virtually impossible for us to go to the hospital, view the slides, and be able to come up with any kind of evaluation?
No, Your Honor, and that's an excellent point. There is no record evidence by the defendant that the access being offered was unreasonable. We simply had counsel saying that. We don't want to come. You're denying us the opportunity to come. But there were no affidavits or depositions or anything else.
And your expert did not view the original slides?
Our expert did not view the original slides. He did not believe that that was necessary, and that's the only record evidence before the court, that pathologists rely on the descriptions of other pathologists to render their opinions. I think it's also telling in Dr. Sandler's deposition, who is the chief of the defendant's group, she in her deposition opines on why the physician's diagnosis and reading of the slides was appropriate without herself ever having looked at the slides.
As a follow-up to my colleague's question, was there any evidentiary hearing held on the issue where determination could be made as to whether or not the constraints placed on the defendant were reasonable?
Yes, Your Honor, it was an evidentiary hearing, and my client moved several documents, including the letter that we've been talking about, into evidence. The defendant simply chose not to enter an affidavit, other depositions, or anything to support their position as far as record evidence goes. It was purely argument.
So is there any record evidence that we could look to from which we could conclude that it was unreasonable?
No, Your Honor. There's not. It's pure argument of counsel. If Your Honors have any other questions, I'll be happy to address them, but I think we've talked about all the points I needed to discuss.
Thank you, counsel.
Thank you, Your Honor. It says, I guess it's getting...
You just got another 43 seconds, but go ahead.
Okay.
I don't think counsel is going to object. Go ahead.
Your Honor, in response, let me address a couple of the things that were said first off. The sequestration, if you, they say they didn't have access. If you read Sharon Harris's deposition at page 148, lines 6 through 23, you had access just like any other time if you had an authorization. So sequestration only made it so that the hospital wouldn't lose them. Took it out of the main thing, but same
Counsel,
access.
I think in part the question is whether or not the record is deficient of any evidence that this court could look to make a determination as to whether or not there was an unreasonable restriction.
Well,
I mean, it's basically opposing counsel suggested it's a matter of argument by counsel, but there's no record evidence.
it was, and I didn't anticipate this question, and so I want to I hope my memory is absolutely correct. But I know opposing counsel and I talked about that, and it's my memory that as far as, well, let me say, as far as, you know, certainly, first of all, we put a lot of stuff into evidence. You know, it was all attached. We didn't, I'm trying to remember our agreement was that we didn't have to do anything to authenticate it. It was all agreed that it was all true. So what is in the appendix is the evidence along with the argument explaining it. What is in the appendix and before the court is, and it's admitted.
It deals with the correspondence back and forth.
Yeah, et cetera. And it's admitted that we never got an authorization. That they don't contend that they've ever sent us one. So that there is evidence, Your Honor. There is plenty of evidence, I think, that procedurally my clients were denied their rights under Chapter 766. The analogy to an IME doesn't make any, isn't really related. Chain of custody, Your Honor, there was an argument about, I don't want to argue about things you don't care about, but it's all there in that order that was submitted to them that they never went forward with. There's been an order now, but there's very little changes in it. But chain of custody, it was protected. Sequestration, spoliation was always their remedy. That's why we were prejudiced. They never were. If we lost those slides, we would have to pay them their total damages. It'd be the greatest thing that ever happened to the co-defendant, too. So we take 100% under the law of the responsibility and the chance of something bad happening. So, there's no prejudice to them, never was. The prejudice would be 100% on us, and much to the delight of the co-defendant. Your Honor, I think what is clear here is that this is a procedural denial of our rights under the medical malpractice statute as the pre-suit statute the legislature put in there to try to allow the parties and the defendant, who only has a short period of time compared to the plaintiff, to fully investigate it, determine it the way, use the experts they want, to have real access, they didn't say a little access. I can tell you no access is the case. You can make access and no access. It's illusory, and it was illusory here. But all he really had to do to make the argument they're doing is send me an authorization that we asked for at least 7 times. I think that's pretty much it. Thank you, Your Honor.
Thank you, counsel. Thank you, both counsel, and court will be in recess.